Kausab, as you are aware that the target audience for our this playlist is primarily the young teachers. Would you like to explain to the young teachers the role of these aids in the interpretation process?
Yeah, I think we must tell our young teachers that they must be first able to make a distinction between internal aids and external aids. Now, internal aids are part of the statute. They have been passed by the legislature and is the collective will of the legislature. But they are not to be treated on par with the operative part of the statute. They are aids which are to be applied when the operative part of statute read as a whole leaves some ambiguity. And if that ambiguity is there, that ambiguity must be resolved by taking help of these internal aids. Now, let me give an illustration. In one of the cases, Bishambar Singh versus State of Bihar, a very landmark judgment on land abolition act. Now, it gave enough powers to the government to decide on the abolition of the land. Section 3 gave unfettered powers, and this provision came for challenge before the Supreme Court. Supreme Court said, yes, undoubtedly, this section does not lay down the guidelines. Therefore, on the face of it, it appears to be arbitrary. But let us look at the two preambles and the long title to this statute. And from that, it found that it said all land to be abolished. Now, it's a colossal task for the administration at one go to abolish the land and pay the compensation and also have the infrastructure to deal with this taking over of the land and handing it over to the people to come to their possession. Therefore, it said that long title and preamble to this act read with section 3 lays down the guidelines. That is why presumption about the constitutionality, I think, is a very important. Every legislation is presumed to be constitutional unless you prove otherwise. The onus of proof is on you to prove that it's unconstitutional. Court said these two internal aids are good guidelines for the government to decide how it has to be abolished. It can't be done in one go. So they have to apply judiciously their mind and choose how best to subserve the purpose of this legislation. But if you can bring individual cases of mala fide before the courts can look into them. So this is a very beautiful way of explaining to the students as to what is the importance of the long title and preamble as internal aids. In fact, there was one of the judgments, Bengal immunity case, where the marginal note was used by the Supreme Court for the purposes of arriving at the legislative intent, because they said operative part of the provision of the Constitution was ambiguous. So therefore, that ambiguity has to be resolved by applying marginal notes as an internal aid of the statute.
Yes, came to the rest.
Yes, yes. But when we go to the external aids, they are outside the statute. So they cannot be equated with the internal aids. Now, like suppose debate in the Constituent Assembly, debates in the Parliament House, statement and objects of the reasons, because once you put the bill in the House, you have the objects and reason. Over the period of the debate in the House, maybe the primary object of the legislation is substituted with something more laudable. So therefore, the object and reason may change itself. So therefore, these can be by caution taken into account to understand the object of the legislation and not the legislative intent. Though there is one case where Justice Krishna Iyer says that over the period of time, this the artificial barrier drawn between the internal aid and external aid seems to be now getting obliterated. But then they found in that case, even by resorting to the external aids, the object of the that provision could not be sorted out. So therefore, but then the principle they lay down that over the period of time, it may become necessary to obliterate to some extent the distinction between internal aids and external aids. But external aids have to be applied with caution, because debates on the Constituent Assembly or Parliament are individual opinion of the member, while as when we pass the bill, it's the collective will of the legislature.
Yes, yes. Now, with regard to the rules of interpretation, while the Supreme Court is seized of a matter in a particular case requiring interpretation, what do you think should be the weight assigned by the courts to this? And also, in a different case where they are dealing with the welfare legislation. So there are
I
two
think,
situations.
you see, when we have to interpret the constitutional provisions, I personally find court, Supreme Court has been very cautious. Uh, it did not want to adopt what they call as, literal rule of interpretation, but they want to apply what they call as purposive construction. One of the illustrations I can give to you is a very famous case. I am very fond of that case. It is S.R. Chaudhary.
Okay.
It was a case where, in the same life of the legislature, a person was about to complete 6 months, because he was not a member of the House. He was about to complete 6 months period, which is the maximum period you can become minister. If you want to continue as a minister, you have to come into the House as the lower house or upper house. So he resigned. There was a change in the chief minister. The next chief minister came from the same party during the life of the same house,
Yes.
and they appointed him as the minister. Now, this appointment was challenged in the Punjab and Haryana High Court. Punjab and Haryana High Court dismissed this petition in the limine. But it came in before the Supreme Court, and Supreme Court, beautiful judgment, S.R. Chaudhary, and court said why we must adopt purposive construction. They said this is an exceptional provision. This must be used in a grave necessity. But if you allow these provisions of the Constitution with a laudable object to be defeated by this process, it will lead to the defeat of the very purpose of the legislation of this constitutional provision, 146 subclause 4 of the Constitution, which says that maximum period during the life of that house, he can be a minister for 6 months only. So they said purposive construction to be adopted to subserve the purpose of the legislation, because a minister has to be answerable to the house. House has to be answerable to the people, and there's a link between people, house, and the minister. So therefore, they have all to be accountable to each other. A beautiful judgment. I think the best rule that can be applied by the Supreme Court in all the provisions of the Constitution interpretation is the purposive construction. Similarly, when we are dealing with the welfare legislation, we must adopt the construction which we call as beneficial construction. So that is, or what we call as utras magis valet quod paret, that is reasonable construction. So the point that is to be kept in mind is how best to subserve the purpose for which the legislation is considered. I'll give you one example. When the Minimum Wages Act was passed in 1948, and when the Constitution of India came into force, the constitutional validity of this legislation was challenged on the ground that it interferes with the right of the employer to carry on business. Now, this is one of the guarantees under Article 19. So, court said, minimum wage is irrespective of the capacity of the employer to pay. And if an employer cannot pay this wage, he has no right to exist. They said, right to carry on business is not absolute right. It is subject to reasonable restrictions, and Minimum Wages Act is a reasonable restriction on the right of the employer to carry on business. So the purposive construction, beneficial construction was adopted by the Supreme Court.
Comes into play. Now, we come to the presumptions that are there, like you had said that.
Yeah, like we say, one of the most important and which must be taught to the students is the presumption relating to the constitutionality. And I will come from that to a very important rule of construction. Purpose of the court must not ordinarily declare a legislation unconstitutional. A legislation can be declared unconstitutional on two bases. One, either it is beyond the competence of the legislature to make a law, or it is violative of the fundamental rights or provisions of the Constitution. Right? Now, when you challenge the constitutional validity of the legislation, courts shall presume, of course, rebuttable presumption, that it is constitutional. But if you are able to prove on either of these two grounds
Yes.
that it is unconstitutional, court will be slow, but it will have to, because if it satisfies the test of violation of either of the two limitations, then there is still further ground, which I think must be taught to the students, and that was what was applied in RMDC's case again.
Yes.
That was the case of severability test. That
Say
was
that again.
severability
Okay.
test. That is, see whether the statute, insofar as it is unconstitutional with respect to certain provisions, can the statute stand on its own with respect to other provisions of the statute? And to that extent, you apply the test of severability. And that was very beautifully explained by the Supreme Court, again in RMDC's case. So RMDC's case, they said if we apply the literal rule, we'll apply the rule of severability. If we apply the mischief rule, then we read down the definition of price competition and make the whole statute workable. Now, these are very, very important aspects.
Whether it can still
uphold to some extent. Like, Jalan Industries was one of the cases where Payment of Bonus Act 1965 came for challenge, and therefore some provisions were declared unconstitutional, but with respect to other parts, severability test. It doesn't go lock, stock, and barrel. That's right.
Now, apart from classroom teaching, sorry, for interpretation of statutes, are there any other teaching aids that can be resorted to?
Yeah, I think two areas that I would emphasize. We must inculcate habit in the students and induct them into the this exercise of legislative drafting.
Legislative drafting.
Give them a subject.
Yes.
Let the teacher explain to them how this bill has to be drafted.
Yes.
And what rules have to be kept in mind. What are the internal aids? What are the operative part of the statutes? How a bill is divided into different parts, so that they have a conspectus.
Architecture.
Yes, architecture. Yes. That's what I said. Bony skeleton they must be able to draw.
Yes. Yes.
Then you have mock parliaments. Put this bill.
Okay.
In the parliament.
Right.
Mock parliament. Debate it.
Okay.
And see which provisions need modifications, which provisions need to be put as they are, and then, signify that debate and make it a very important part of the classroom teaching.
With all humility, when I was with the MET, then the first part I practiced, that the students were divided into a group of 6, and they were made to draft a simple legislation.
Very simple.
But the second part, bringing it for a parliamentary debate, I think that is an eye-opener that should also be used.
You see, this is how you can not only confine legal education to lawyers, judges, but you can also extend it to parliamentarians, so that tomorrow the boys, some of them can go to the parliament and they are already trained in this process.
And they would be sort of. Now, the next aspect I would like you to deliberate is on the assignment of projects to the students.
Very important. I will tell you my experiences. It takes me, even today, not less than 3 hours to read a serious case, which I have already read.
3 hours?
Yes. When I have to go for a lecture in Judicial Academy or somewhere on the virtual platform, or otherwise also, because I'm very fond of talking to people, interacting with people, I will not go without preparations. And I will devote between the lines. If you see my case book, it has different colors marked on each line. Is how I think best teachers are those who read case law
Okay.
thoroughly. Thoroughly does not mean head notes. Head notes are not
Yes,
part
yes.
of the judgment. They are editorial stuff, you know. You must read the whole of the judgment. Then you must be able to grain in the chef which parts are most important parts.
Yes.
I have firm belief that those law schools which are able to bring out their own case materials are training their teachers into a very, very important and effective way of becoming a good teacher. I went only for less than a year to VIPS, Vivekananda.
Yes.
In that 1 year, I brought out 10 case materials. And I think some of them are better than Delhi University case material. 20 were in the
Very
pipeline, but then, I could not find
Yes.
myself adjusting to the private environment.
Yes.
And I found I could do better outside. And I thought profession was a better place for me.
Yes.
So I think it's very important that this exercise must be taken by every law school.
Yes.
And if a person has to become a teacher of interpretation of statutes, he must be able to bring out the best of the case material. I'll tell you, when I prepared case material for Delhi University, I went to the 7th floor of Indian Law Institute to find the important cases on English law, which I found in Maxwell's book, and I thought they were the best cases to teach. And I took the from the original source and printed them in the case material of Delhi University.
That would be very useful. And the last question that I have for you, Professor Kaul, sir, that with regard to confirmation or assessment, should the traditional mode of 5 questions in 3 hours, or would you prefer an objective type?
I would not, I would say problems,
Yes.
problem questions. Problem questions used to be when I was a student in Delhi University. That time, our teachers, that was a galaxy of the teachers. I think we're very fortunate to have the best of the teachers who have all along been the best teachers in legal education. They would prepare each question paper, new question, and that would be blend of many cases.
Okay.
They would bring in many issues that would come in for discussion.
Yes.
And then you would have to answer those questions. I think not that mugging should not be the, and nor should be this objective A, B, C, D. I certainly, I want for no, I don't subscribe to that.
Yes.
It's a question of no, I don't think. I think that method I don't subscribe. I don't subscribe to that.
You have very well brought out that this problem method where
very important. Yes, and you must connect various issues relating to that subject and bring them in the form of a problem and say you answer this question. Yes, yes, whether they have internalized the law and the judicial decisions and the subject matter.
Thank you very much, Professor Kaul. Your presentation has been simply brilliant, and I'm sure this would continue to help guide and educate the future generation of law teachers.
Thank you very much, sir. Thank you very much.